Good morning. Today's discussion will be in relation to the ongoing topic of our First Nations people, and whether or not there needs to be reforms to the Commonwealth Constitution of Australia to empower our Aboriginal and Torres Strait Islanders and protect them and their history. First of all, why do we need to recognise Aboriginal and Torres Strait Islanders in the Constitution? There are two reasons for the change. Firstly, is the symbolic value of recognising the first Australian people in our Constitution. The Indigenous people have been living in Australia for over 50,000 years, until 250 years ago when the British came and settled in Australia and determined that it was not inhabited and therefore terra nullius, and took the land for themselves. Granting the Indigenous a binding notation in the Australian Constitution will build a positive relationship based on trust and mutual respect between the Aboriginal, Torres Strait Islanders and the rest of the country. Secondly, is the value of the constitutional reform in contributing to the greater protection of the rights of Aboriginal and Torres Strait Islanders. The Indigenous were treated as fauna until the referendum in 1967. They were unable to vote in their own country. They were treated as if they would be gone soon and would no longer be an issue. With the constitutional heads of power within the Australian Constitution, there are two sections which seem to be racist and proposed to be changed. Firstly, Section 25, provision as to races disqualified from voting. This gives the power to be able to exclude an entire race from being able to vote. Considering this is exactly what happened around 50 years ago, and there is no purpose except to discriminate, it is put to the Parliament that we need to have this excluded from our Constitution. Secondly, is Section 51, subsection 26. This section, the so-called race power, has been interpreted by the High Court to allow the Federal Parliament to make laws that discriminate adversely on the basis of race. Parliament only ever used the race's power regarding Aboriginal and Torres Strait Islander people. The removal of this would safeguard against laws such as the Aboriginal Ordinance of 1918 in Northern Territory, which is contested by the Kruger and Commonwealth case, which was passed under Section 122 of the Constitution and legitimised the removal of Indigenous children from their parents and the mandatory detention of Indigenous people on supposed welfare grounds. The separation of powers and the roles of the government. The need of the Parliament to enact this change to the Constitution is due to the Australian political system's reliance upon it. Our system has three arms of government: the Parliament, who create the law, the Judicial, who make the decision based on the laws, and the Executive, who enforce the laws. The judicial system denies its authority to determine validity of the laws until they are enacted. They recognise that they are a separate body to the Parliament. Courts are simply there to enact laws passed by the Parliament, and if we had protection within our Constitution for the Indigenous people, this would give the courts a stronger power to protect the country's first people. With human rights, we are the only country within the world who don't have a treaty with its Indigenous people. Only months ago, we passed a Queensland Human Rights Act. Most other states have their own separate acts. As well as that, we have signed an Australian international human rights obligation under the International Covenant on Civil and Political Rights. Part of our obligations are to allow recognition and equality before the law, the right of life, rights of Aboriginal and Torres Strait Islander people, the rights not to be subject to torture, cruel, inhumane or degrading treatment, the right not to be subject to medical treatment or experimentation without consent. Through the short history of Australia, there have been multiple testing on Indigenous, including 7 nuclear tests in the Maralinga site in South Australia in the 1950s and 60s. Also, the rights of the family and children. We have passed laws allowing us to remove the children from the Indigenous, which is based off welfare. The rights of minority to enjoy their culture. The Indigenous people do not have a written language like the Western civilizations. They share information through education, through story, dance, and song. In the recent documentary by Sir David Attenborough, on which he was looking at the history of the Great Barrier Reef, where it was discovered that the Aboriginal stories of creation of the reef and now mirrored by science. However, these stories of the Aboriginals are thousands of years old. The importance of knowing the history is essential to humanity, and by destroying one of the oldest cultures in the world, we would erase a major part of our history and knowledge. The history and treatment of the Indigenous people in Australia is horrific and needs to have further protections in place. For an amendment to the Constitution, we need a referendum. Section 128 of the Commonwealth of Australian Constitution Act gives power to make amendments to the Constitution. The key steps to holding a referendum is the proposed changes to the Constitution that set out in a bill to the Parliament. The bill needs to be passed with the absolute majority of both houses. This is why, in the past, a lot of referendums are not passed, because of starting a referendum, there needs to be undeniable support for the change. Australia, at the moment, seems to be gaining more and more support for the Indigenous people, so timing will be crucial in this matter. The referendum will be put to the public to vote 2 to 6 months after the bill is passed by the Parliament. It needs to pass a majority of voters in a majority of states, generally 4 out of the 6. This is called the double majority. After this passes, it will go forward for a royal assent by the Queen and subsequently the Governor-General. As such, the Constitution will now be altered. The publicity of the referendum is crucial. As we have seen in the past from the 1967 vote, it was passed with just over 90% of the votes. There is no use trying to change the Constitution until the right time to hold the majority of votes. There are multiple acts through the country which protect against racism, including the Anti-Discrimination Act. However, these are simply acts in which can be changed at any given time. Forcing the government to have these sections placed in the Constitution guarantees the safety of our Indigenous people, knowing that they would not be able to change it overnight and not without a majority of the country's vote. And this will be essential for the survival of the Indigenous people.